OMA, my lord. I only apply for the defendants.
Okay. Yes. Enoma?
My lord.
Yes, this matter is for.
My lord, you informed that the matter was slated for adoption, my lord.
Okay, thank you. Yes. Are you ready?
Subject to the court's convenience, my lord, we are ready to adopt the meeting address.
Okay. Falade,
Yes, my lord.
are you ready?
Yes, I'm ready, but I have a little constraint.
Only lawyers that speak double and politicians. Yes, I am ready. I have to so you don't know whether I am ready or not. Yes, let us hear your little constraint.
The constraint that I have, my lord, is that I don't have the file with me.
Is that part of our problem? Is that part of my problem or that of the other counsel? Don't you know you are telling me I should not even grant you audience? You are appearing before me without a file and you are telling me you don't have file. Is this a marketplace? Is that how less serious you take the court?
I'm sorry, my lord. I
Don't
just
tell
need.
me you don't have file. Because if you are appearing before me
my lord,
physically in court and you say you don't have file, I will let you out.
My lord,
So don't tell me you don't have file.
My lord, please, I just need the date of the filing, my lord, so that I can move the application, my lord.
Yeah, so I am the one that filed it now. I'm the one that filed it. So I will give you the date because I'm the one who filed it.
You want to call the other lawyer and get the details. Yes. Yeah, maybe they're not in good list.
My lord, this appearance is in an impromptu one, and I wasn't prepared for it at all.
The one who made you to appear impromptu, isn't it?
as the court pleases.
I'm the one who made you to appear impromptu. Enoma, move your adopt your.
Going to my lord.
Yes.
My lord.
Yes.
Based on the direction of this honorable court.
Yes.
We find the meeting address.
Yes.
On does a suspended member of an association have the local standard to sue to enforce the provisions of the association's constitution?
Yes.
The said address was ordered by this court on the 24th of May 2021.
It's on my record.
Yes, my lord. We find our address. The address is dated 18th day of June 2021. It was filed on the same day, my lord.
Yes.
We wished to humbly adopt this address, my lord.
Yes.
As our argument.
I urge the court to do what?
We urge the court to strike out this suit, my lord. Seeing as the claimants do not have a local standard to have instituted this suit in the first place.
So, supposing the claimant to challenge his suspension.
My lord, I'm afraid I'm going to ask you to come again. Your audio is not as clear.
I will come again. I will come again. Supposing the claimant
yes, my
was
lord.
properly suspended, which we are yet to find out.
Yes, my lord.
Will he lose the local standard to sue, to challenge his suspension?
That is our position, my lord.
He cannot even challenge the suspension.
My lord, our position is that for him to challenge his suspension, one, there's a modus operandi that was prescribed by the articles of the Constitution of the Association.
Then you didn't get the point.
It's just that channel, my lord. I can proceed to conventional court.
The point the court raised is the man is challenging his suspension. He is also asking the court to force the association to conduct election. So in the event that the court finds out that his suspension was correct, would to challenge the association on the basis of the so this issue only led to his challenging the election and asking us to force the association to conduct election. He will not affect his local standard to go to court and say, I was improperly suspended. It's only when we find that he was properly suspended that this issue becomes right. If he was not properly suspended, he remains a valid member, and then he can validly, we will not even need a question of whether or not he can
local standard
now, isn't it?
Yes, my lord.
So thank you very much. We
ask
the court to strike out the suit.
Yes, my lord.
But the written address of counsel for the claimant dated 7th June 2011, 2021, and filed on 15th June 2021 is hereby being adopted.
As you please.
You know why I did that? Because the council appearing doesn't have it.
Not the file, my lord. Yes, my lord.
Yes, he doesn't have it. He cannot say when did she file, what did they say? So the court, but the rules allow the court to adopt even if they are absent.
As you
so I am treating it as if counsel is absent.
As you please.
We can do nothing. If we go by her, we will ask for adjournment. So
we are grateful.
If the counsel was in court, I would have drawn his attention. He titled his written address on the issue so motu raised by this honorable court. That's all. That's how he titled it. But you see that you are on is properly titled written address on those a suspended member of an association have the local standard to sue to enforce the provisions of the association constitution. That was the question, and that's what you are addressing.
Yes, my lord.
So that when it becomes, when I determine the suspension, it can go one way or the other.
As you please.
Then what next? Then this question will come up, may come up. And that's why we couldn't write this judgment. We couldn't move anywhere. It's all right. So, case adjourned to 28th September 2021 for judgment.
My lord, you said 28th of September.
Yes.
We are grateful, my lord.
It's by Zoom.
As you please.
You will use, they will give you, you will get the new Zoom ID for that day or you get it from Shola. He will send you the Zoom ID that you are going to use for that day.
As the call, please.
Thank
We are
you.
grateful, my lord.
All right.
Thank you very much, my lord.
Okay, thank you. Falade, tell Faliokai next time if he wants to send you to court, he should give you the file, or else you will not represent him, because it is you that suffers embarrassment.
This is.
Thank you very much. You are welcome and have a nice day.
You too, my lord. We are grateful, my lord.
Yes. Ogule.
Yes, my lord.
Yes. Olayinka, Olajide, and 6 others versus Non-Academic Staff Union of Education Associated Institution and 11 others. Is that your case?
Yes, my lord.
Okay. Appearances.
May it please my noble lord.
Okay.
Samson,
Just a moment. Just a moment. Ogule.
Yes, my lord.
Ogule.
Yes, my lord.
This matter was supposed to be by physical, but we are made to understand that you are out of town. So you are joining.
Yes, I was out of.
So I said you should give him, because he will have to be on Zoom.
Yes,
But I saw him just standing up.
Yes, I'm
He's already on Zoom. So sit down and enjoy the privilege of the sun. When on Zoom, you have to enjoy the privilege of a sun.
As a copy
Because I couldn't see you. You were standing there, but I couldn't see you.
As a copy
But did you see him, Ogule?
My lord.
You didn't put on your video.
Oh.
Shall I have him put on the video? So only him will be a son today. Okay.
That's a copy.
Occupying sunset. Oh, how many people? Even 4 people. So you have another son behind. Okay, let's take the appearance, please.
May it please my noble lord.
Yes.
Samson Ayode Jaino is my name.
Samson
Ayode Jaino, my lord.
Ayode.
Aino. Aino is spelled
A. Okay, I see Ayodeji. I know on the this thing.
With me is
okay.
Is Angela Fatu Ashe.
Who?
Angela Fatu Ashe, my lord.
Angela
Fatu Ashe.
Fatu. FATU.
ASE. For the claimants, for the applicants, my lord.
Claimant applicant?
Yes, my lord.
Okay. Yes.
With due respect to my lord.
Yes.
I am being Unleye. I announced my appearance for the defendant.
Respondent.
Applicant.
Applicants also. Everybody is an applicant. It's okay. At least, we will put you as respondent for now, but it doesn't matter. You are still an applicant in the motion. Yes. Let me know the motion so that we know who is taking first. Yes.
Our motion is we have an application before the court.
Yes.
For another of this honorable court.
Yes.
For an injunction restraining the second and third respondent, my lord.
Yes.
From inaugurating the 4th to 12th respondent, my lord, as a caretaker committee or whatsoever so called of the first respondent, Ekiti State University branch, my lord. And another of these honorable court restraining them from parading themselves, my lord. as the caretaker committee or whatever.
What I needed from you is to identify his file on so date.
My Lord, the motion is dated 19th of January 2021, my Lord, and filed on the 26th of January 2021, my Lord.
Because I can see a lot of motions upon motions in this file. Filed when?
It was filed on the 26th of January, my Lord, 2021. 26th of January 2021, my Lord.
Is that not when you filed the case?
Yes, my Lord. The motion was filed alongside the originating summons.
Okay, so instead of arguing that motion, why won't you simply argue the originating summons, just take that for judgment?
Yes, my Lord, but then the respondent counsel only filed the notice of criminal rejection, my Lord, without filing the counter affidavit to our originating summons. And aside that, my Lord, the respondents in this case, my Lord, they've already themselves and there are a lot of shenanigans going on, my Lord. So there is need for us to restrain them, my Lord.
See, they have been aware of this ongoing case. You filed this motion in January.
Yes, my Lord.
This is July. If they have not yet done what you wanted us to restrain them from doing
They are
since
still
January.
doing it, my Lord. They are doing it. They are currently doing it, my Lord. University is recognizing them as the caretaker committee without even inauguration.
The matter is ready for hearing, it's right for hearing.
But they didn't find their counter. We are ready to adopt our originating summons, my Lord.
Yes, now. So if the date of the judgment is the date of the same ruling, I don't know if I'm communicating. Whether you argue that motion or not, as long as you have argued the main case, on that day I'm simply giving final judgment, isn't it?
Yes, my Lord. But the good thing is that the respondent did not even oppose our motion, my Lord.
But it doesn't matter. That's not what we are talking about here. Okay, we should take the motion first and leave the originating summons.
Please.
Is that what you want?
Yes, my Lord. We appreciate, my Lord, to take our motion first because they filed a notice of criminal objection to our originating summons, and we have filed. Although they ought to file their notice of criminal objection alongside their counter affidavit.
In that case, we will take the PO first. Then I will rule first. Then we go to your motion. If that's the way you want it.
Lord, we are yet to file our written address in response to the PO is ready, but we are yet to file, my Lord.
See, the man that is accusing them of not filing counter affidavit with something. You too, you have not filed response to the PO that was filed in
the practice I'm used to is that once an originating summons has been issued, the respondent can file, who wishes to file a PO should file alongside their counter. So we too can respond and as well file our reply.
You filed in February, you have not responded. You want us to give you date to respond. Meanwhile, there is something here challenging my jurisdiction. So I want to determine my jurisdiction first before I know whether I can issue any order in the matter.
As a public.
So that means we have to take a date.
For hearing of the originating summons and alongside with the PO.
No, for the PO.
The please, my Lord.
That's what you choose. Isn't it?
Well, my Lord, I will appreciate it. So whereby we can hear both the PO and the originating summons at once. So why give
That's what I was saying now. That's what I wanted to do. You are insisting on motion when you know there is already a PO challenging jurisdiction. The rules allows me to take the case together with the PO, then I will rule at once.
The court pleases, my Lord.
You always understand when the court is saying something. I can only do it when I take the PO with your originating summons at once. I cannot close my eyes to his PO and begin to determine your motion or notice for injunction. What if I give injunction and then at the end I discover that the PO succeeds, I don't have jurisdiction?
As the court pleases, we take the hint of the court.
So there are just two ways. It's either we wait till we finish with the PO before we go to the matter, or we take the originating summons and the PO together now. So I will rule all at once. Which one is your choice?
You know, we pick the latter.
Eh?
We pick the latter, my lord, so that we can decide everything once and for all.
Okay. Ayodeji, we are ready to argue our summons, isn't it?
As a couple, is it?
Together with the PO. Thank you. Ogunleye.
Hello.
Yes.
Yes, we have a notice of preliminary objection challenging.
Yes.
Division of the court.
So they say they are ready to argue, including your PO.
Yes, my lord, I'm ready.
Thank you very much. So you go first.
Yes, my lord.
My lord, I think I misunderstood it. Huh? It will be at a later date because we are here to file our response. We have a written address here to the PO, but we are here to file.
I don't know. I was not speaking Hausa. I would have accused myself of not speaking proper Hausa for you to understand. I was speaking English. I don't know English more than you. And I'm sure you don't know English more than me. Because you and I, we were taught English up to secondary school only. And then they continued using English to teach us everything. Isn't it? Or did you read English beyond secondary school?
Not at all.
At least you read English up to secondary school.
Very well,
you passed enough to read law.
Very well.
Apart from that, okay, at least I know in year one, they taught us some English and some literature, GST courses. They taught you too.
Very well.
After that one, nothing. So none of us, between me and you, none of us knows English language more than the other. And I spoke English. And the other lawyers are here, they heard us. I said it is either we take everything together with the PO now, or if you want to insist on your motion, then it means I have to determine the PO first to see if I have, because when we argue together, is the PO I must first determine. So I say, or maybe I have to take the PO first and determine whether I have jurisdiction before we come to your case. Which one do you choose? You chose the latter, which was to take, although this time around is the former. The way I put it now, it is the former, which is to take the PO together with your originating summons. And the thing is, this thing, when were you served? You have come back. Okay, let me put you on record. What did you say about the PO? What you just said now, let me put you on record.
Okay, my lord. We, on our part, my lord,
yes,
shall be asking for an adjournment. Shall be asking for an adjournment.
Yes.
That's the response. The respondent notice of criminal.
When were you served the PO?
Lord, I don't have the date here, my lord.
No, you have. Because for you to know that you have time, that you still have time to file your response, then you must know. Don't tell me you don't have the date. How did you know that you still have any time at all to file response, such that we can even suspend today's proceeding for you to file?
It is I believe that if you have of time, you can still come by way of motion.
Come and show me. You know, part of my problem is you people. But when we have issues like this, and then I will not see anything in my file. No service of. Okay, good. Samson Ayedele, he collected it 9th March 2021, 2:37 p.m. You signed by yourself in March. We are in July. You have not responded. Today is for hearing. You are telling me you are yet to respond. Is it fair?
Well, you know, we tell you apologize, but it's not.
And you are for claimant. When we leave court today, what happened to your case? What will they say? The court adjourned the matter. Is it me that adjourned the matter? If I insist we go ahead now, you will say, the court didn't want to hear my response on PO. Want a fair hearing. But are you being fair to your clients? March to July.
The one that is not fair to us, but we don't want to just go deeply into
No.
On our part,
if you receive a process on behalf of your client in March, you signed it, and this is July, and you have not yet responded. You are not being fair.
We're not mobilized, We're not mobilized to do that, but we've prepared our processes.
Who did not mobilize you?
The client mobilized me. Up to now.
To find counter affidavit. You will leave their case to hang on. You have already accepted their case. You have filed, you are before me. You leave their case to hang from March to July because they have not mobilized you. As if you cannot do it and give them the bill. How much is the bill for counter affidavit? No. That is not how we were taught this law. See, what these people, they have a problem. They have nobody who can help them to ventilate their problem. They are trusting in you. They believe in you now. And then you are telling me it's all about the money.
But no, it is not all about money.
So why should their case go from March to July without you responding? Today, I think they are these ones. Your clients are the ones that have filled the court. You are not.
On our part, we've done this, we prepared these processes since, even during the strike. But there is no way we can use our money to file and as well serve the other party outside the judicial.
You filed a motion ex parte, and I think I granted it.
Yes, that was on the
restraining fever and response on calling Congress.
Yes, my lord.
And then you are still asking for that motion to restrain them. Wow. We have restrained them from calling Congress.
But they went ahead to call the Congress. They are still parading themselves. That is why we want to move this other motion.
Where is the affidavit that they went ahead to hold the Congress?
None has been filed.
Okay, there is this motion on notice. Who filed it? Benjamin Ogunleye.
I'm the woman.
Order of Honorable Court.
Asking the court
of time to file for the discharge of the order of interim injunction made ex parte, which was made on this. Has that motion been moved? Has that
no, my lord, that's the motion.
Okay. Ogunleye.
My lord.
You are not ready to move that motion?
I'm ready, my lord. I told my lord that I have a motion. If they are speaking for an adjournment, that motion should be, and that order needs to, that interim order should be discharged.
To move your motion. Dated and filed on 18th May 2021. Is that?
Yes, my lord.
Okay. Ayodeji.
My Lord.
Yes, he wants to move his motion.
No, my Lord.
I granted another ex parte, and he wants me to discharge the order. And he wants to move the motion. Are you ready?
We are ready, my Lord.
Okay. Ogunleye, move your motion.
Yes, my Lord. Before I move my motion, my Lord, I did not receive any counter affidavit from the claimant.
Yes, because I have not received any either, or let me say the court has not received any either. So you can move in terms.
Yes, my Lord, I move in terms of the motion paper. And at the same time, my Lord, I adopt the written address attached to the motion as my argument in support of the motion. I urge your lordship to discharge the order of interim injunction made ex parte on the 23rd day of March 2021.
What is your reason? You know, I will not just grant being opposed. You must convince me yourself.
My Lord, our David clearly states that the facts relied upon were all misrepresentation.
Okay. Paragraph what? Did you say that the facts relied upon were all misrepresentation?
Paragraph F, my Lord, I mean 4F, in fact, the entire 4.
There is 4A to H. I want to see the particular place that you said all his facts he misrepresented.
My Lord, paragraph 4F.
Forward.
4. Paragraph 4. D.
I didn't see any reason given here, if not because you said C, when you say that this order was granted in view of the claimant's Exhibit A attached by the claimants. That's all they are. So what happened to Exhibit A? But there is nothing that amounts to a reason in this your paragraph 4. You are just giving me statement of facts here. What is the ground? What is the thing that vitiates the ex parte order according to this your affidavit?
My Lord, if they have disclosed to your lordship by our paragraph 4I that it is on the record of this honorable court as seen in the claimant affidavit in support of originating summons dated on the 7th day of November 2019 in suit number NICNAK/51/2019, which was withdrawn and struck out, that the executive committee which the claimant was.
Which paragraph are you reading? Counsel, which paragraph of the affidavit are you reading?
Paragraph 4I, my Lord. I
don't have any 4I, I just have 4H. And it says that the claimant will be prejudiced by the grant of this application.
No, we have 4I, my lord.
You have now. Me, I don't have.
I don't have it.
Is it your own process I'm using, or the one you filed in my court that I'm using?
Yes, it's the one I filed in your court, my lord.
Paragraph 4I of the affidavit.
Yes, I have I. That's David. All right.
Come. You find two different. No, this one is. You find two different motions on the same day?
No, I didn't file two different motions.
You see, one of the problems I have now is people refuse to paginate your work. You could have told me on page this. You can't tell me that now. Your paragraph 4 is on what page?
After the motion, my lord, the affidavit is support.
The motion is the whole paper up to your written address. So paragraph 4I of the affidavit that we are talking about is on what page? Because
that's supposed to be page 5, my lord.
Here I have paragraph 4 to E. And then in 1, I have paragraph 4. I have 2 copies here in my file, and they are different. And they are all filed. They are, one is dated 29 April 2021 and filed 18th May 2021. And in the affidavit, paragraph 4 to H is paragraph 4 to H. Then there is a second one, dated 29 April 2021, filed on the 18th May 2021, the same prayers, but the affidavit by Justin Ezu Dara has paragraph 4A to E only. So I don't know which one are you moving. Then you seem to have one with you there that has paragraph 4A to I. See, you follow here, problem. Yes.
Because even that paragraph ends in D. I said the paragraph 4 of the affidavit,
yes,
ended in 8.
Read the paragraph 4. Let me hear you.
As the copy.
It has
I was informed by Benjamin A. Ogule, a council. A to P.
A to E.
A, B, C, D, E, F. No, to P, P, Peter.
A, B, C, D, E, F.
A to P. A, B, C, D, E, F.
Then the network is also helping.
G, H, M, N, O.
Well, I don't have that motion before me. I don't have that motion before me.
Because the motion was actually filed during during this fight.
So the reason for the application is as per our paragraph what?
4I.
4I.
Yes. My Lord, the issue is this.
Stop there. Stop there first.
That it is on the record of this honorable court, as seen in the claimant affidavit in support of originating summons, dated 27th of November 2019, in suit number NICN/AK/51 2019, which was withdrawn.
Ogunleye, for now, I'm trying to tell you that this is my court. And I said stop there, so stop there and listen to me. Now listen, there are two motions in the court's file, all dated 29th April 2021 and filed on 18th May 2021. One affidavit has paragraph 4A to H, while the other has paragraph 4A to E. There is no motion before the court with paragraph 4I. It is clear that there is a confusion here that needs to be sorted out. So, Ogunleye, what do you say? Having heard what I said now, what do you say?
Well, my Lord, in view of the confusion, which really, to my greatest surprise, and unfortunately, I'm not in court. I need to ask for a stand down to sort the issue out. There is nothing we can do than to ask for.
You ask for a stand down. You are not here. The other counsel is here physically. You are not here, and you are asking for a stand down. Or did I not hear you well? You are asking for what? You asked for what?
I have been in court. The audio is having I'm saying that in view of the fact that I'm not in court to sort out the issue, then there is something I can do that will ask for an adjournment.
Oh, okay. I have stand down. Yes, Samson?
No, we shall not be opposing the application.
First of all, do you have the motion with paragraph 4I?
Not for me, Lord. The motion before me, the one I was served, only have paragraph 4, A to E, followed by paragraph 5, 6, I.
What of the one with paragraph 4, A to H?
Yes, that is another motion for enlargement.
It's the same prayers.
No, it's for extension, my Lord. There are different prayers, my Lord. The other motion I have here is for extension of time.
Okay. Extension of time. Okay. For him to make that up. Oh, Jesus Christ. Why now, lawyers? So you file a separate motion to ask for extension of time to bring this application. Then you file the application separately the same day. When you should simply prayer 1, extension of time, prayer 2, you ask for the thing. You see why you have confused us? So it is the one for extension of time that has A to H.
Yes, my Lord.
Then the main application now has A to E. Okay. I do not have the motion with paragraph 4 A to I, but paragraph 4 A to E, isn't it? That's what you say.
As the copy is below.
Okay. So what is your response now to his application for adjournment?
No, we shall not be opposing. We shall not be opposing the application for adjournment. No.
Give us date.
May we be guided by.
Okay, this case is adjourned to 25th October 2021 for hearing. And for your information and all counsel, you people are plenty here. From now henceforth, this court shall enforce the rule on adjournments.
I'm sorry, my Lord, I didn't hear you well.
25th October 2021 for hearing. Physical.
As copies.
Physical, gentlemen, come here. Then I'm saying from now henceforth, this court shall enforce the rule on adjournments strictly. We will not tolerate adjournments beyond the limit you are entitled to according to the rules. So go and study our rules. How many adjournments are you entitled to? So that you don't begin to get mad when I say, well, you have exhausted your chances. Either this case proceeds or I strike it out. You get mad with me in court. That one will be a cup of tea. Go and read our rules so that now henceforth you should be careful how you ask for adjournments in this court. Thank you. Any other Zoom matter? Okay, Ogole, we are through with the Zoom matter for today. And I think Nima is leave. I am leaving because Abuja is the host. So you can leave.